Howdy, folks. Welcome. Dave Brannen here. We're ready for Ask a Lawyer live, I guess. We are definitely live. So we're here today for some questions. I'm going to be talking a little bit about how you calculate severance in employment cases and just getting ready for the end of the week. I'm going to be taking a couple of days off here. I got my mother coming to town for a visit, so that's always interesting, picking her up tomorrow. But for today anyway, all yours. We're going to be answering questions and talking about severance pay. All right. So severance pay, also called termination pay, is something that you are entitled to in Canada if you've been let go from employment by your employer, in most cases anyway. Now, whether you've just been let go or you're preparing for it in the future, it's critical to understand how it works and how much money you might be entitled to make sure that you don't get underpaid and to understand if you might be owed money if your employer is trying to fire you without paying you anything. So let's go over this. So when someone is let go from a job, there's two types of compensation. And, let me just fix my screen here a little bit, sorry. There we go. So there's two types of compensation that you often hear about: termination pay and severance pay. They're often used interchangeably, but they're not the same thing. There is some nuance here that I want to cover. So termination pay is the minimum pay that must be paid to you under the Employment Standards Act of your province. Okay, so it's a little different in each province, but that is technically what is considered termination pay. Severance pay is something that you see in provinces like Ontario, where there is additional compensation paid to long service employees, usually beyond 5 years, and it's an additional amount that's paid under the Employment Standards Act to certain employees. Now, on top of that, there's something called common law notice, which is what courts will say you should receive in addition to any amounts payable under the Employment Standards Act. Okay, so common law notice is often also called termination pay. It's all kind of lumped in together here, but we're just trying to be technical about it. So there is the amounts that are owed under the statutes, the employment standards statutes. That is typically to be called termination pay. There's common law notice, which basically extends the amount of pay that you're owed. All right, let's look at some Now, there is a myth out there that there's 1 month per year of service. Sometimes you hear this as 1 week per year of service often. So it's anywhere from, you hear from 1 week to 1 month. Um, this is not really the law. The real entitlements are often more than 1 week. Sometimes they can be worth more than 1 month per year of service. So there's not really a rule of thumb that you can go by. The amounts can be actually quite different depending on the factors. And the factors that courts will look at, so it's a very case-by-case assessment on how much severance pay you're owed if you're entitled to common law pay. If you're only entitled to the statutory pay, then it will be whatever it is under the statute. Usually most of those cap at about 8 weeks, no matter how long you've worked there. So for most people to get beyond 8 weeks of pay, you need to be entitled to the common law termination pay and severance pay. So the common law pay is only in situations where your common law rights have not been overridden by your employment contract. So some employment contracts will override the right to common law pay, and I'll get into that in a second. But first of all, let's talk about what determines the amount of pay. So when you're talking about common law pay, the amount is going to be determined by your age, how long you worked there, the character of your employment. So was it a senior role? Was it more specialized? And the availability of similar jobs in the economy. Now that right now with the Trump tariffs and all this stuff, it's caused quite a disruption. So we are seeing like that is an argument we can use, that it will take someone longer to find work and can result in more common law notice pay. So with length of service, like the longer you've worked for a company, usually the more notice you're entitled to, and that equates to more termination pay. And the age, the older you are, generally speaking, the older you are, the harder it is to find other work. So you're often entitled to more notice, with like the highest notice going to older employees who have long lengths of service. They are often going to get the most pay. All right. So let's look at the common law versus the employment standards. Now, one of the biggest traps employees fall into is assuming that what they're offered based on the employment standards is the full amount you're entitled to. Now, a lot of people, can do their own research and figure out that they're owed more than that, but that is important to understand. Under the common law, many employees can get much more than just the 8 weeks maximum that you'll see under these employment standards. You can often get like double, triple that amount. Even when you have an employment contract that includes termination provisions that say you are limited to or that sort of say that they're trying to limit your compensation to the amounts in the Employment Standards Act, even if that is in your employment contract, you should still have a lawyer look at it. The courts, especially in Ontario, will not enforce those types of clauses if they're out of compliance at all with the Employment Standards Act. Okay, we see these all the time where someone will have this type of clause in their contract, and we can see there are ways to have that clause thrown out of court, especially in Ontario. Less so in other provinces. Ontario has certainly been the most aggressive with throwing out these termination clauses. So when I say throw them out, it means they just won't apply them. So what they'll say is, even though the contract is trying to limit this employee to the minimum amounts in the Employment Standards Act, because they can't go below that, we are going to say that those clauses are void. So this employee is entitled to common law notice, which is often double, triple the amounts that they're entitled to under only the Employment Standards Act. Okay, so another key thing is you don't want to sign a release, because doing so that's when you're expressly giving up your rights. And so some employers will try to put pressure on you to accept the deal. They might sweeten it a little bit and say, we'll give you the minimum amount out of the employment standards plus another week or 5 weeks or a month or 2 months or 3 months, whatever it is. Sometimes they will try to sweeten it by giving you extra money but put pressure on you to sign now. They do that because they want you to not get a lawyer. They want you to, it's just like anything. Putting pressure on people can cause people to do something they might ordinarily not want to do, or they might delay the decision. So you'll see that oftentimes when people put a lot of pressure on you to sign. We had a recent case where we're arguing that the pressure the employer put on the employee was inappropriate, and that is a reason to make the release that they signed void. Now, I wouldn't rely on that. You're better off not signing a release and then seeing a lawyer before you sign the release rather than sign the release and then realize you probably made a mistake and go see a lawyer at that point. It's going to be hard to get the release thrown out unless there's very compelling reasons. And the case that I was talking about here, that person we're representing, they did have a good argument for why the release should be thrown out and not upheld by the courts. So some practical tips. Let me just go over a few of these. So first of all, just don't assume, I assume most people won't do this, but don't assume the severance offer, the termination pay offer is correct or fair. They will often start with a lower amount just to see if you will take it. Most employers will have room to negotiate, even with you, if you go back to them wanting them to pay a little bit more. So just keep that in mind. Again, like, consult a lawyer before you sign anything. It's very hard to undo some of these deals if you sign them, having read it. Get advice from a lawyer before you sign any type of agreement to end your employment. And keep copies of all your employment documentation, things that you're allowed to have, like your termination letter, your contract, anything you're offered to sign. Like, lawyers who are advising you are going to want to see all that. It's very important for the lawyer to see your employment contract because that has such an impact on what your rights are in any given situation. All right, and that's it. So if you know anyone that's been let go from employment, or if you've been let go from employment, just get them to reach out to us. We can review the situation and give people some idea of what their options are. We often can do it, to a certain extent, we can do it by a free consultation. But if it's more complicated, it may need to be a paid consultation. We represent people in employment cases on both fixed rates, so a fixed fee amount where you pay it X amount of dollars for the service, or we do it on a contingency fee where we will only get paid based on a percentage of whatever severance we can negotiate for you. Okay, let's dive into some questions. We got someone putting questions in here now. Let's have a look. This one says, what happens to medical benefits, i.e. dental, medicine, etc., when you go off on LTD, but then later the LTD opens via recurrence? My LTD coordinator said the employer deals with those benefits. That is correct. So often you think of your benefits as all being one thing, but your long-term disability is one of several group benefits you have. When you are approved under a long-term disability claim, they are just responsible for that claim and what's payable under that policy. Not the full group policy, but the LTD portion of that group policy. So most LTD insurers are only going to be responsible to pay you for the monthly benefit and a waiver of premium benefit. They're not responsible for other things. So things like ongoing access to medical, dental, etc., that is all subject to your employer's, it's subject to what the employer wants to agree to allow have happen. It's not unusual that those benefits can stop while you continue. Your LTD claim will remain open, but you may not be able to continue to make ongoing claims for the medical, dental, and all that. So it is correct when your LTD coordinator said the employer deals with those benefits. That is something that is between you and the employer. Some employers allow employees to stay on their group benefits for medical, dental, etc. for years. Others will take you off it right away. So it really depends on the agreement that the employer has with the group benefits provider and what your employer is willing to do. Typically, if you're in a smaller business, smaller employers, they're going to get you off these plans sooner rather than later. The people that can usually stay on these plans the longest are going to be like government workers or very large companies where they have the deals in place with the group provider to allow employees on sick leave to stay on the plan. The problem with having employees on sick leave on these plans is that if you're a smaller employer, that will greatly increase the cost of the plan for everyone. And so you will see employers in these situations wanting to not allow people on sick leave to stay on the medical plan just for financial reasons. It's legal to do as long as they're not singling you out and they're treating you the same as any other employee, then they're allowed to do that. All right, let's look at this other question. Is an employee entitled to a severance package after going on LTD after several years? The reason for getting off LTD is having a new job. Well, you're not necessarily entitled to a severance package if you just because you have left an employer. So, for example, in a situation where you've been off on LTD and you are trying to go back to work to a new employer, that would be considered you resigning, even though you may not have formally resigned from your previous employer where you had the LTD benefits. That would be considered resigning your employment, so you would not be entitled to any payment from the old employer. You're only entitled to severance pay in Canada when you have been terminated your employment by the employer, so that they have stopped your employment. That is the only situation where you're entitled to pay. If you resign or leave the employment, you are not entitled to severance pay from the employer. It's only if the employer is ending the employment agreement against your will, kind of speak, and that they would owe you the payment. Very good questions, though. Okay, just let me know if people have other questions about that. In the meantime, I'm going to check out the forum here to see if there's any questions I can answer today. Yep, there looks like there was one. So let's go have a peek here. We can answer this question together. See if you guys can help me out. Share screen. So this is someone who's posted a question in here. Let's go have a look at it. All right, this one says, okay, yeah. This one says, thank you. This is helpful. This information is dependent on the insurer and their wordings. Is your second permit? Okay, this is a complicated one. It says here, you can I answered some questions here. Okay, let's just start at the top and work through this. If you're on a return to work plan, your current job has offered a job with a different employer. Is it advisable to take it? Oh, sorry, but you were offered a job with a different employer. The reason I ask is the insurance company and current employer are making it a living hell. Okay, so this is very similar to what this other person was asking. Like, can you, if you're on LTD, can you return to work with a different employer? And I said you can always change job. Your current LTD claim is not tied to your current employment. If you have a relapse after going to the new employer, then you could restart your LTD claim if you are still covered under the relapse policy. The downside of change of jobs is that once you pass the relapse period, the current claim, you may not qualify to make a new claim with a new employer until you've worked continuously for a year or two. I would even amend this to say that actually, I'm going to amend it right here. However, there are some LTD policies that only allow the recurrence if you return to the original employer. Okay. There we go. So then this person replied, someone replied, thank you. Is the information dependent on the insurer and their wordings? Is your second premise based on a pre-existing condition clause of sorts? Okay. This one says, I think some employers don't cover pre-existing conditions at all, my former employer. Yeah. So for the first part, let me just see here. What does it say? So it is based on the pre-existing condition wording in the new group policy. The insurer has limited obligations to work with any employer, um, including a new employer. Their only obligations are what is specified in the policy, and it is usually very open-ended for them to decide. The new employer is not obligated So the new employer is obligated to make accommodations if they hire you. Yeah. So that is interesting. Like your current employer, it's often better to try to stay employed with your current employer that you have. It's often better to stay with your current employer because they have an existing obligation to accommodate your disability short of undue hardship. But if you do go with a new employer, the new employer will still, if they hire you, they will have an obligation to accommodate you short of undue hardship. The thing is, they can choose not to hire you, is what often happens. Or during the, if they might just not let you get past the probation period. So there's usually like a 90-day probation period where they could fire you basically for any reason. They'd still not supposed to do it for disability reasons, but if they feel like they can generally get away with firing people within the probation period, so they wouldn't have to necessarily accommodate. There we go. I'm going to put this in here. Boy, that's a little late. A little bit late, but better late than never, I guess. Other people will read this. Okay, we had another comment here from Imran. Let's see here. In a contractor role, when the insurance asks for what's your pay rate, am I supposed to give them the rate that my company as a contractor is receiving, as in my case, the company is getting paid? Um, that is a complicated answer. Yeah. It won't necessarily be the amount your company is getting. It would be what you are being paid in your role that you're doing on behalf of the company. So I guess it's if it's your own company, maybe this is. So if you're working at, so yeah, it's going to be complicated. If you are working through a corporation, but you are really the main employee of the corporation, then it could be the amount they're paying you, the corporation as a whole. But if you're working for a corporation, there's several employees, you're on a salary, this kind of thing, then it would be what your salary is. But again, if you're artificially, the problem with being in your own corporation is you can fudge all the numbers and make your salary whatever you want and all these kinds of things. So the insurer just may want more information. I would have to see the policy that you're dealing with in order to kind of make sense of what they're looking for. But probably in a case like this, you would just need to give them, they're usually going to want to see like the financial statements from your corporation. If you are this, if it's a corporation where you're really the main employee, they're going to want to see the full financial statement probably from the corporation to try to figure out what the pay should be. It's complicated in those kind of situations to figure out how it should be done. Okay, do we got any other questions on the forum? It looks like not. It looks like I'm caught up. Now that I'm answering these pretty frequently. Oh, someone had sent me an email. That is correct. Can't forget about that. Let me go find it. Let's see here. Jen had sent it to me. There we go. Okay. I'm going to see if I can cut and paste this in here. See if I can do this. Oof. All right. Okay. Okay, let's see how I can do this so I can keep the person private. All right, I know what to do. Here we go. I'm just cut and paste it on something here so we can look at it. There it is. There it is. So let me share my screen. Bingo. Okay, here's the question. It says, my lawsuit against an insurance company resulted in a settlement earlier this May. My question is, I've not heard anything from my employer, so how long can they keep me on medical leave? I have PTSD about going back there because their bad management resulted in a severe burnout. Do I wait for my employee to initiate severance, or can I request a severance payout? Okay. Or do they first decide what they're going to let me go? I'm on CPP disability since last month, but CPP is not forever, and at some point in the next 5 years, I may have to go back to some kind of work. Okay. All right, so this is an interesting question here. My lawsuit settled earlier in May. So they had a lawsuit settled earlier in May. Now, normally when a lawsuit settles, the insurance will notify the employer. So the employer should be on notice that your LTD is settled. Typically, an employer at that point is going to reach out to you and determine, if you settle an LTD claim, it's settled on the basis of no admission of liability or anything. So it's up in the air whether you are actually disabled or not. There's been when you settle a case out of court like this, there's no decision on whether you're actually disabled or not. So the employer will usually reach out to find out, are you actually coming back to work now that you've settled the case? What is your plans? If you've been off work for a fair number of years, I don't know how long you've been off, but you're getting CPP disability. The fact you're getting CPP disability, that would be grounds for your employer to argue a frustration of contract. Okay, so a frustration of contract is a situation where it limits what employers have to pay to the employee for any type of severance pay. Outside of Ontario, and I think maybe Alberta and BC, I'd have to double check that. There's only a few provinces where, well, let's play it the other way. Most provinces, if there's a frustration of contract, the employer does not have to pay any termination pay whatsoever. In Ontario, and I believe BC and Alberta, I'd have to double check that, but certainly in Ontario, even if there is a termination for frustration of contract, the employer still has to pay the bare minimums. They have to pay so in Ontario, employer must pay the Employment Standard Act minimums. Only if they terminate you, though. So right now, they have not terminated you. So if they chose to do so, assuming you're in Ontario, I don't know if you are, though, but if you're in Ontario, assuming the employer wants to terminate you for frustration of contract, then they would have to pay the ESA minimums. That's if they decide to terminate you. You don't have a right to reach out to them and ask them for severance because you're not really owed severance unless they plan to terminate you. If you reach out to them and say, my thing's done, I would like you now to pay me severance, they're going to say, yeah, no, we're just going to not do that. We're going to wait. They may, like, if they get any idea that you are going to go back to work somewhere else, then you would be resigning your employment. And they wouldn't owe you anything, even this minimum. Okay. They might owe you some, like, vacation time or something that you had banked up or something like that. They could owe you something like that, but they wouldn't owe you termination pay if you are just going to go work somewhere else. So you kind of are at a point where really there's not a whole lot you can do. You can't ask them for severance because that is almost like you resigning. And if you resign, they don't owe you anything. It's kind of there's a bit of a dance there, but a lot of people think that they are owed severance pay if they leave. You're not owed it. You're only owed it if the employer terminates your employment without giving you notice. So if the employer gives you notice, then you're not entitled to any pay. Like if an employer says, we're going to terminate your employment on, in 5 weeks, but keep working in the meantime, then you just keep working in the meantime and you're paid, but you are not owed any money beyond that if they've given a fair amount of notice, right? I once had a client in a long-term disability case where she did return to work and the employer gave her 2 years notice of termination. So she continued to work there for 2 years. And then at the end of the 2 years, she was let go and wasn't owed any money beyond the 2 years that she continued to work there. So just keep that in mind. If this person is in the chat, please post some questions if you want me to follow up on this. Now, it says the second part here, it says I'm on CPP disability since last month. Okay, so you just got on CPP. CPP is not forever. No, it only goes to age 65. And at some point in the next 5 years, I may have to go back to work. So if you're on CPP disability and you will want to go back to work, then you should contact the CPP, something called the vocational rehabilitation program through Service Canada. Okay, you should go through that program if you're going to try to go back to work, because you may have the best intentions and need to work, but you may not be able to hold down a job and do it, even though you want to. So going through the vocational program makes it so that they allow you to keep getting your CPP while you're trying to go back to work. They can give you additional resources to help you find a job. And if within the first 2 years of trying to go back to work it fails, then you immediately go back on CPP rather than have to apply and go through all the process again. The other thing you avoid with this program is the problem of, like, you may start working and earn more than you meant to, and next thing now you owe money back to CPP and you haven't set some aside, so you can get yourself into a whole mess. You don't want to do that. Go through the vocational rehabilitation program if you decide you want to try to go back to work at some time. All right, let's just save this here. There we go. Okay. Let me stop sharing. Looks like we got some more questions here. Let's go have a look. Why does CPP require new employer name when one is getting off of CPP disability? Do they contact the new employer? I've informed them that I'm joining a new employer, but also told them not to reach out to the new employer. I reached out, I asked them about the vocational coordinator. It's been a few days, but I haven't heard back. How long does it take them to reach out? It could take a few weeks to get it straightened out from them, honestly. They want the name of the new employer because they want it for their records. They want to be able to track, like, if you're going to get, they have to track, like, your income that you're getting from the new employer. So this is just stuff they want for their records, just to keep track of it. Who is the new employer? What kind of job are you doing? They would need all of that information. Now, if you don't want them to reach out to the new employer, just make it very clear to them. They're not necessarily going to do that without your permission, but give it a week or two for this vocational thing to be set up, and then you could, when you get the vocational person, like you have a regular contact person that you can talk to who's a real person, not just calling into a call center and it's just some rando person. So once you get the vocational person, then you can be more like talk to them about your concerns, why you don't want them to reach out to your employer and kind of ruin it. Like it makes sense you wouldn't want your employer to get these weird calls from Service Canada and all that kind of thing. But make sure you do get into the program so that there will be no issues for you. Here's one from Class A. Would employers know if you start receiving CPP, and if and how so? Um, would an employer, so I guess what you're saying, if you start getting CPP disability, would the employer know? Not necessarily. The only way they would know is if you had signed some type of release that allowed Service Canada to reach out to your employer, then possibly they could contact the employer for some information or something they could find out inadvertently that way. But generally speaking, the employer don't have access to any of that information, so there's no way. Like it would in the reverse could happen, like CPP can definitely find out if you're working somewhere because they have the ability to monitor your tax returns and different types of things like audits like that. So that's often how it comes through. Like they'll get a red flag that you have reported. Like a basic principle is if you're on CPP disability, you're receiving benefits, you're not supposed to be paying into the program. They can make exceptions if you are only earning a certain amount of money. If you're under the threshold for when you have to pay into CPP, they can make exceptions and things there because you're not technically paying into CPP if you're under, well, you might be paying in, but you're under the threshold for contributions or whatever. So where they will get notices is if they've got active CPP recipients, CPP disability recipients who are also paying into the program above the minimum threshold payment. That's when they get a red flag to know you're working, and you want to be the one telling them that that's going on, not having them find it out. But as far as the employer knowing, I don't know that there's any way the employer would find out. The only way they could is if, again, CPP gets a red flag that you're paying into the program above the the minimum threshold amount. You've passed that threshold for paying into the program because of your income on the year, then I guess it's conceivable that if they knew who the employer was, they could reach out if you've given them an authorization to do so. But in most cases, they're not going to do that. This one says, do employers give notice ahead of time, or do they give you a chance to come back and try to work? It really depends on the employer. So remember, employers have an obligation to accommodate your disability. So the employer, if they're smart, if you've settled in a long-term disability claim, the employer they still have an independent obligation to figure out, are you capable of coming back to work with some type of accommodation? They have to decide that. They have a duty to engage in that process. Now, you also have an obligation to stay in touch with your employer and to keep them informed. So if you get in a situation where you're not following up with the employer, it could be a situation where you seem to have abandoned your job. I always recommend like following up with the employer if you are in one of these limbo situations. So you definitely just don't want to wait for the employer. Like if you've settled your long-term disability case and you said the employer hasn't reached out to you, like you probably should reach out to them to let them know that you've settled the case and either tell them that you would like to return to work or that you continue to be incapable of returning to work. You should tell them one of two things just to keep the communication there. If you don't contact them at all, like it does open the argument that maybe you've abandoned your job, although most times it wouldn't be found that way, but it just opens that they could argue that for you. So the employers have an obligation to allow you to try to come back if you have medical clearance that you're capable of doing the job with either with no accommodations or with some accommodations. Accommodations mean reasonable changes to the environment or work conditions that would allow you to do the job. This one here says, hi, David, I worked for a company just shy of 1 year, had a work-related injury that left me unable to do the demands of job, was terminated in January 2023, never received any severance. What am I entitled? Just shy of 1 year, had a work-related injury. It would depend on the termination. The problem is January 2023, it's over 2 years ago, so you probably are past the dead, like based on what you're telling me, like that would be too late. You'd be beyond the 2 years limitation period to make a claim against the employer. But if you only worked there for less than a year, you would not have been entitled to much for termination pay. If you had a workplace injury, you were probably getting workers' compensation, I would think. So I would assume there was a workers' compensation claim probably in there. Now, typically, workers' compensation is not happy to see them terminate employees while they're on workers' compensation and this kind of thing. So, you know, if less working 1 year, you might have been entitled to like a week, depending on your province, you'd be entitled to 1 to 2 weeks of pay under the Employment Standards Act. And then depending on your situation, it could be a bit more under the common law. But again, if it was a situation where you were incapable of doing the job, then it could be a frustration of contract situation, and they wouldn't necessarily owe you anything unless you're in Ontario. And if you're in Ontario, they might owe you a week or two based on the Employment Standards Act. Great questions, by the way. I love it when people are throwing questions at me. Love it. Give it some more time to see if people have other questions. All right. I think we'll call it a day. Thanks for all the questions, folks. We'll be back on Monday. So look forward to seeing you guys back then. We'll be talking, I think Monday is CPP disability, so we'll be talking that. Bring all your questions, and I look forward to seeing you guys later. Take care. Have a good evening.